transferred to a phone number so and so belonging to Sani Ali, and also taken an amount of rupees 30,000 me by CSP and snatched away the gold necklace. It is informed before your honor that we have suspected the manager Rahul of the Hotel Seven Heaven is also involved along with the said person. Only in this FIR, my lord, we are not named, my lord. Now, lordship may have a look at page 5, my lord. Now, page 5, my lord, I have narrated the facts of the case, my lord. May I read, my lord? The actual fact of the case is the informant and his friends named in the affair have to pay some money to the accused petitioner. And in this regard, there was some sort of altercation in form of hot speech among them. However, subsequently, money was paid to the petitioners. The informant, out of anger, lodged the instant affair, stating some false allegation against the petitioner. Relying upon the allegation as made in the affair, the investigating agency merely on suspicion have arrested the present petitioner without proper investigation of the next paragraph, my lord. The petitioner most humbly submit that thereafter arrest of the petitioner, the dispute between the parties have amicably settled under the intervention of the elderly persons of the locality, and the money which was paid by the informant to the accused person have already been returned to the informant as per condition of the amicable settlement. In this regard, the informant has already received the said money amounting to rupees 1,11,000 from the father of the accused petitioner number 1, and the money received dated so and so is acknowledged by the informant. So the informant has no objection if the honorable court is pleased to grant bail to the accused petitioner. Now your lordship will have a look at page 25, my lord.
Yeah, money receipt.
Money receipt, my lord. 25, my lord.
You are appearing for information.
Yes. They have all amicably settled, my lord.
No objection. So, but okay, interim, this can be given, but let us call for the diary.
My lord,
Because there's an allegation of impersonation as the
Yes,
income tax officer. I don't know why.
Fine.
That is third NJ Dr. Learned Counsel. We am from for the informant and DP Goswami. Invoking 483 petitioners are seeking bail. Hatigaon PS case number 19 of 26. They were arrested on 25/1 and 26/1 respectively. The gist of the allegation in the FIR dated 18/1/26 is about some persons impersonating as income tax officers and forcefully extorting money from the petitioners by threatening them about their threatening them about any involvement in online game stuff. They submitted that the allegations are false, drawing attention to para 5 and 6 of the bail petition from Mr. Dr. Learned Counsel submits that the allegations are distorted, concocted and false. Full stop. And the fact of the matter is that the petitioner and the informant side are friends, and due to some dispute over money, some altercations took place, leading to registration of the case. And in the meantime, the money that was supposed to have been returned, paid, has been returned. And in support of the same, money receipt has been exhibited, has been annexed to the petition. The Learned Counsel for the informant supports the said facts and submits that the matter has been amicably settled, and he has no objection to grant of bail. Nevertheless, call for the case diary. However, in the interim, 15,000 with one security of the light each. The satisfaction, to the satisfaction of the concerned learned court.
CGF Kamrup
Metro, and subject to the condition that they shall cooperate with the investigation and shall not hamper or tamper agreements. This is the matter towards the end of February.
And 25/2.
25/2.
I'm obliged, deeply obliged.
52. This case, your lordship, the petitioner is behind bar for 90 days. Okay. Your lordship has already granted bail to other co-accused, your lordship. All the other co-accused are enlarged on bail, your lordship.
His case, yes, some people were,
Lords.
he's not one of them. He was
He-
not one of them in that case.
Lordship.
In that petition, he was not one of them, right?
No, he was not there.
Forgotten.
All the other
PID.
lords. On the, your lordship length, considering the length of detention, your lordship. Granted this. Today is the
Charge sheet
19th.
has been submitted,
Charge sheet is subject, we have to take instruction, it is charge sheet submitted or not.
but any case,
Lords.
this aspect also has to be seen, parity aspect
Yes.
has to be seen. Mhm. You take an instruction, otherwise.
বাকি গুলো 86
খবরটা লই পেলাই দি দিও।
86 days. Granted.
Mr. Bothakur, I'll mail ID. Mr. Bothakur, learned counsel submits that as on today, the petitioner has completed 90 days
Yes.
in under trial detention and the applicable statutory period vis-a-vis the penal provisions given is also 90 days. That's all. Submitting three orders of this court. They submitted that the remaining accused persons.
Lordship, he is the only remaining.
Remaining, the other accused persons of this present case have already been enlarged on bail. Stop. Then, it's okay then. Should we take
After
instruction?
some time, lordship, I will take instruction then.
Otherwise, we'll have to consider this. Any case, we have to consider
No,
this,
no.
even if it is charged sheeted. After some time, then. Okay?
Lords.
After some,
It is the.
you take the instruction. Prosecution would like to take the instruction.
May I plead the lordship, my lord, this is a 483 application, my lord.
Okay.
That earlier they have approached before this honorable court and their bail has been rejected, my lord. The petitioner was arrested on, my lord, 11/12/2025, my lord.
So what was this matter?
So, my lord, at this stage, the up-to-date case diary may be called for, my lord.
Is it? Anyway, yeah, we'll see. It was last rejected long time back.
My lord, page 44 on 9/1/2023.
For the latest one, no?
Yes, my lord,
Latest.
9/1/2023.
Yeah, we can see. it, no problem. Mr. DP Bora. DP Goswami, Mr. Bora fairly submits that earlier bail petition where petitions were rejected by this court at that stage and with the last one being on 9/1/2026 and praise for calling the up-to-date case. Murajhar PS case 109, up-to-date case. The petitioner was arrested on.
On 11/12/2025.
The petitioners, present petitioners are in custody since 11/12/2026, 25. When do you propose that?
17 to.
My lord, can it be on 16 to come wrong? On 16 to, my lord.
Okay.
Oblige, my lord.
Motion 88. Item number 8.
This report was called, there is no effect.
Report was called for.
A report received, lordship. The subject, I have the honor to respectfully submit before your honor that a case has been registered against the petitioner, namely Rafizul Haq.
Okay.
And it is further submitted that the investigating officer in the case has been unable to submit a case diary within this stipulated time as he has been engaged in law and order. So,
Law and order.
case is registered, so
Abdul Manan, no. Only one person.
against Rafizul Haq, it is Rafizul Haq.
My order is the previous order. Previous order 9/1, two persons have been mentioned, where the case has been registered in Rafiqul Haq and Abdul Manan. Two persons.
Here of it, we have only on against the Rafizul Haq, so
Maybe it is,
Zainal
not-
Abedi.
maybe not registered.
As Alopatisa case, PS case number 43/25. Yes.
In the context of order dated 9/1/2026, a report dated, Goswami,
Lordship,
report dated
report dated lordship. 31/22/2026.
31/2030, right? 301/2026, stating that case name,
Case name, PS case number 43/20.
now which police station?
Alopatichar, ALOPATICHAR.
Alopati
Patichar.
Thar Police Station, which district?
Is district from
Borpeta.
Borpeta.
Follow police of, PS case number
43/25 and
under so and so section.
25.
Give the report to.
Lordship.
Return back to. Against Rafiqul Haq. But case diary could not be sent due to the IO being busy for law and order duty. Full stop. Issue reminder for the case diary. Full stop. The interim order shall continue
There is no interim.
and no, there is interim, no coercive action I have given. Because we do not know what is the, what section, what is the sections?
The Lordship, as per 61/2, I have even reported.
61 to 318, 305E.
The cheating and theft.
Theft.
There is no theft. Government has already sanctioned 2020. But police had only harassment that he has only said that with the investigation of company, they had mislead.
Because we
Some
do not
people-
know, na, FIR, we don't have nothing. So
But let the
actually,
case diary will come, Lordship.
in a way, because the interim order is there, it should not be vacated also, but at the same time, we have to, pass order in by guesswork.
Lordship.
Because we don't know the FIR, don't know anything, whether it justifies
Yes,
interim
yes.
or not, we don't know. In the event of arrest in connection with those so and so, they shall be allowed to go on bail of rupees 25,000 with one surety of the like amount to the satisfaction of the arresting authority and subject to the condition that the petitioner shall fully cooperate with the investigation and appear before the IO for making themselves available for examination, shall not hamper or temper it. Is the matter and get it next week,
Next week,
not later than next week.
Lordship. Then 11/2.
11 to. You can take it back if you want. This one.
Not also part of the capital record.
Obliged.
9.
May I please, Lord.
Yes.
482 application, Lordship. There are 4 petitioners, Lordship, out of same family, Lordship. 1, 2, and 3 are brothers, Lordship, and 4 is their father. FIR is page 11, Lordship. Basically, one minor boy is missing, Lordship, and the father of the victim lodged a complaint, missing complaint, Lordship. He suspect the present petitioner
Minor boy, huh?
minor boy, Lordship. Before registering this FIR, we have appeared before the IO, Lordship. But now the case is registered, Lordship. not
Human
available,
transfer,
Lordship.
trafficking is. Acha. Mr. Gosam, I'll need your assistance.
Lordship.
Here is the petition, so and so, so and so.
After perusal of the case diary, Lordship. Case 19.
Mhm.
Last paragraph. From the case diary, it appears that on the basis of the written adjournment filed by the informant E.R. Ali, OC Borpeta PS registered the instant case against the accused petition under section so and so. It is alleged that the accused persons kidnapped a 16-year-old son. The informant IO is yet.
Why are they being suspected? Anything,
Yes, Lordship.
anything that you have been instructed, why they are,
But IO has yet to recover the alleged kidnapping of the informant
okay.
on that time of this or delivering the order also. And the case diary it further appears that IO searched the equipment, but they avoided police arrest. So at this stage, case diary may be called for because as per the order, the minor boy has not been recovered yet.
If possible, get it on 9th.
Lordship.
I want to see it early. Borpeta PS case number. 356 of 2025. At this stage, let it be. Yeah, we'll see on Monday. Because since 9/2.
9.
Obliged.
Item number 10.
Yes.
May I please? 10 and 11 of the same FIR, Lordship.
Case 10?
Next item is also the same FIR.
Page 13.
Lordship, FIR is at page 10, Lordship,
Page 10.
and the original is at 12.
Mhm.
Case has been registered
Mm.
with that I would like to
Mm.
draw your attention that the today on 13/11,
Mhm.
the belonged accused persons belonging to Muslim community, equipped
Yes,
with
sir.
machete, etc.
CD was here also with regard to some other bail
Some
application.
other, the arrested person, lordship, these are the pre-arrest bail, lordship. I'm one of the FIR named accused, lordship here. Number 3, Sahidul Islam.
Mhm.
The actual incident has been referred in next, I have another FIR, lordship, at page 20. For the same incident, the victim has lodged an FIR, lordship. And in that case, the FIR has been registered on all the bailable sections. There is a land dispute, lordship.
Victim.
May I read, lordship? সম্মানপূর্বক বিনোদন আবেদনে যে যোৱা 8 বছর ধরে উল্লেখিত আসামিগণে বৰবিল স্থিত মোট 30 বিঘা মাটিত বলপূৰ্বকভাৱে দখল কৰি খেতি-বাতি কৰি খাই আছে। যোৱা 7/11/25 ইংৰাজী তাৰিখে মই মোৰ খেতিত হাল মাৰিব যাওঁতে উল্লেখিত আসামিগণে হাতে হাতে দা লাঠি আদি লৈ মোক প্ৰাণে মাৰিব খেদি আহে। আসামিগণে মোক ৰাস্তা ঘাটে আনকি খেতিত গলে প্ৰাণে হত্যা কৰাৰ হুমকি দিয়ে। That is the actual fact, lordship. We are possessing the land for last 8 to 10 years. According to us, it is for 20 years.
Hmm.
On that day, the informant came to possess the land and there was some quarrel.
This is the.
He
this
lodged an FIR on 13/11, lordship.
is- Okay.
That case was registered on available offences. But as police could not arrest on available offences, the police has registered so much FIR.
Mm.
Earlier CD was here, I have control of case bail also. So fixed it, we have to take instructions
Yeah, I mean,
whether CD is here or not,
I
otherwise,
don't remember the day,
okay,
last week.
last week, this CD is here and we can fix the date, lordship,
We
we'll
can dispose it of also.
dispose it of.
Huh?
Today
You
it
can-
I am here for interim bail also
Yes.
on medical grounds.
Ah, yeah, no, yes.
For my wife.
Do you have an order, copy of that order, which was passed, granting bail?
Granting
Yeah,
bail.
Regular bail, that was regular.
Have been disposed of.
Regular bill.
Anyway, so if
Those
possible.
persons were arrested.
Those, I know, those persons were arrested. Oh, okay, we'll take it after some time. You can see if the CD is here.
That's.
Huh?
Okay. Oh, no, no.
CD may not have gone back.
Not
If we do not get the CD, then I will take up the prayer for interim bail.
Oh, lordship. Next is also same FIR, lordship, 11 for the other 5 accused, lordship. Item number 11,
Okay, 10 and 11.
same
We
FIR,
keep it pending for some time.
lordship.
You take, we can do it in second half also. But after whatever time you take.
All right.
একেলগে কৰিম আৰু। একেলগে কৰিম, মানে এইটো part hearing আছে। একেলগে কৰিম। এইটো।
54.
Yes.
Hey, please, Lord. The anticipatory bail application. The FIR in which we are seeking anticipatory bail, this is a counter FIR, lodged after we had lodged an FIR. The first, your lordship will come to page 16, my lord. This is an FIR which was lodged by the petitioner number 1, my lord. May I read this FIR, my lord?
Mhm.
With due respect, I submit that on 2/12, and your lordship will kindly note the date, 2/12/2025.
Mhm.
At around 4 PM, the below mentioned accused persons attacked my brother Anwar Hussain with a kukuri without any provocation, thereby causing him grievous injuries. At present, my brother is admitted in the hospital. Now, your lordship will kindly come to page 14.
Just a minute. Okay, page 14.
Page 14. This is a photograph of the injuries sustained by
Yes, sir.
his brother, my lord. The lordship will notice, my lord,
Petitioner's brother.
petitioner's brother cut injuries across the face. And next at page 15, your lordship will see
Page
15,
15.
my lord.
This as a,
Yes, my lord. This is regarding this. Sir. Page 15, your lordship has it. My lord, the first category diagnosis. Head injury, multiple incised wounds of scalp, forehead, face, neck, chest, abdomen, left buttock and thighs, and the left finger. These were the injuries sustained by my brother.
Hmm.
On second, I lost this FIR. Now, your lordship will kindly come to page 24. This is a forwarding report for Ainul Haq, my lord.
Ainul Haq, son of Inamul Haq,
Who was arrested?
who was arrested, and your lordship will see the second ground.
Second ground.
During the course of investigation of the case, sufficient evidence had been found that the accused person, against the accused person, that he, along with absconding co-accused person, barbarically attacked upon the injured person by Kukuri. So this is the finding of the investigating officer.
Hmm.
Next page, your lordship will find another forwarding report for another accused, Mukarrim Haq, who is also the son of Inamul Haq. Here also second ground, my lord. Arrested accused person, he was barbarically attacked upon the aggrieved person by Kukuri along with previously arrested.
At page
person.
25, right?
25, my lord,
Mukarim.
Mukarrim. So the IO finds prima facie materials
Mhm.
that the petitioner number one's brother was barbarically attacked with a Kukuri. Your lordship has seen the nature of injury. Now your lordship will come to the FIR, instant FIR, my lord. That your lordship will find at page 27.
Okay.
Here your lordship will see the date. This was on 3rd. So that FIR was lodged on 2nd. This FIR is lodged on 3rd.
It's for 765, no?
Yes,
That
ma'am.
was
And in this case, we are seeking bail. 766, my lord.
this past.
Yes. So here, the accused Ainul Haq
Mhm.
and the two arrested persons, Mukarrim and Inamul, are the sons of, Mukarrim and Ainul are the sons of Inamul Haq. So Inamul Haq lodges this FIR on the other day, next day, alleging that at 4:30 in the afternoon, few miscreants, namely Dildar Hussain, Harun, these are all the petitioners, illegally trespassed into the premises of my house and attacked my younger son Mukarrim with a sharp object for no reason, thereby causing him grievous injury, after which they left. After 1 hour, the aforementioned accused persons conspiring with Khalilur and Jamaluddin entered the premises of my house and set my 6-room house on fire by pouring petrol. So this is an FIR which has been lodged, my lord, a day after we lodged the FIR, in which these informants, 2 sons have already been arrested. Now here they have come up with this allegation that it is we who were the aggressors who entered into his house and attacked him and caused injury to his son Mukarrim. Mukarrim, on the other hand, has already been arrested by the police, my lord. Here they bring in allegations of arson and, my lord, causing grievous hurt. Clearly a case, my lord, which has been lost as an afterthought and as a counterblast,
No, it's not a case of Marpit, mutual Marpit.
not a case of mutual
Not-
market. We were the ones who were attacked, my lord.
Okay. Victims.
And
The
your lordship-
allegations were serious, but the pouring petrol in the set on fire on the house. That's it.
That's true.
And here, your lordship, petitioners number, 2 and 3, they were the ones with whom these persons had a fight.
Mm.
1, 3, 4, 5, and 6, they are neighbors who, when the incident on 2nd happened,
Mm.
they went to the place of occurrence to see what the incident had happened, and they had rescued this Anwar and taken him to the hospital.
Mm.
Now, they have also been implicated in this case.
এটা এখানে সেটা টাইপের কেস যায় লক্ষ্মী
It has to be seen.
Lordship will examine the case diaries of both cases, my lord. I'll humbly pray that both be called for. Then your lordship can see who were the actual aggressors, my lord,
Mm.
and what had actually transpired. But at least some protection may be accorded so at least we can appear, my lord. But clearly, this is a case which came after our case. And our case, my lord, the injuries, we have established the injuries by means of the medical report, and police has also found.
Mm.
Not a case, it's only our claim. Police has also found
Mm.
that this victim was barbarically attacked, my lord.
Yes, Nawaz, learned counsel for the petitioner, EP Goswami.
Number 6.
Invoking 482, the 6 petitioners herein are seeking pre-arrest bail in connection with Tezpur PS case number 766 of 2025. Full stop. The case arose out of an FIR dated 3/12/2025.
26. Okay, 25, my lord.
25. Lodged by one Inamul Haq with allegations about illegal trespass into his premises and attacking his younger son Mukarrim Haq with sharp weapon. And subsequently another attack on their house and setting it on fire. Full stop. The learned counsel has drawn attention to an FIR dated 2/12/2025 logged by
Petitioner number 2.
lodged by Dildar Hussain within bracket petitioner number 2 herein against Mukarim Hussain, the aforementioned Mukarim Hussain and 3 others,
Including the informant, my lord.
including the informant, with the allegation that they on 2/12/2025, the accused persons named in FIR attacked his brother Anwar Hussain with a kukri without any provocation and causing grave injuries. The said case was registered into Tezpur PS case number 764 of 2025 and so and so. Learned Counsel has drawn my attention to an annexed photograph of the purportedly of the said victim brother. Petitioner number 2. Petitioner number 2, right?
Patient number 2, my lord.
Indicating serious injuries on the head. Full stop. A medical document is also been annexed, indicating head injury and multiple incised wounds on the head and head, face, neck, etc. Full stop. The Learned Counsel for the petitioner submits that this FIR has been lodged as a counterblast, roping in some neighbors as well. Full stop. The Learned additional PP 6, the case diary, medical report. Full stop. On the basis of the available materials, it is not clear as to whether the present proceeding, the present case is a counterblast. Full stop. But the Learned Petitioner Counsel contains that it is so. Call for the case diary of Dutale, 764 of 25 and 766 of 2020, along with medical reports. However, in the interim, with a view to enabling the petitioners to record their statements and their version of the events, that it is directed that in the event of their arrest in connection with DD Banamura, Tezpur 766, they may be allowed to go on bail of rupees, how much? 25,000 each with a surety of land arresting authority, subject to conditions, cooperate investigation, appear before the. They shall not commit any illegal activities or offences.
25 to lots.
Okay.
I'm deeply obliged.
You'd like to do the admission, madam?
Yes.
Good, because otherwise I take it after bail. But it is, since you're waiting, there's only one matter.
I'm grateful, my lord.
No issues.
If I may just inform this honorable court, the counsel for the other side
Mm.
who made a mention earlier before listing, and it was at the instant that it was listed, and on the last day they took time, and today they, yes. And today they again want to pray for time. I said at least this prior information would have been good. But anyway,
My
they
lord,
had
this
their
is my
own
case. My
constraints.
case, my lord, I have filed it, my lord. They have filed on the last occasion, after a period of 2 years, my lord, they have filed a objection. We need to file one, my lord, rejoinder. That is all, my lord. What?
I'm not objecting to.
Relax.
I'm not objecting to the, I'm just pointing out, I'm not objecting to the adjournment they are seeking for, but
He's pointing out the
yes,
some.
in a criminal, in a criminal matter,
Mm.
I do not know whether I do not know that what rejoinder needs to be filed. It's not a writ petition before this honorable
True.
court. And this honorable
My lord,
court will ultimately take into consideration the trial court records which is already there.
It is for the basic matter is pertaining to
The basic
cancellation of bail.
Cancellation
of bail.
bail, my lord.
Cancellation of bail granted to one so and so. So you are for the private respondent,
For the accused, yes.
Accused.
private respondent, who's on bail, right?
Yes, my
So
lord.
ED counsel will also be here. I think.
I am the ED counsel.
Also, you are, sorry, you are for the ED. The ED is seeking, the
He is seeking-
prosecuting agency is seeking the cancellation.
Yes. And the time is also sought by them. I have no objection.
Okay, actually, I was right, but I've seen here people filing reply affidavits and all. Any pleading in High Court is by affidavit only, so perhaps because of that. Anyway, the department within bracket ED had filed this petition seeking cancellation of bail granted to the respondent Preeti Pal Singh, I think, right?
Right.
Preeti Pal Singh, it will be. In special PMLA case number 7 of 21, rising out of with case number 854 of 2021. Full stop. So you are filing a revision against the order of rejection of bail cancellation,
Yes, my lord.
or you are seeking bail cancellation
No, my lord.
directly?
My order, my lord, we sought for cancellation of the bail,
which
my
was
lord. That got
rejected.
rejected, my lord.
Full stop. The learned special judge had by order dated 1/10/2022 had rejected the prayer for bail cancellation, and the petitioner is assailing that order. Full stop. Ms. B. Goel, learned counsel, appears for the respondent / accused. It is submitted by the petitioner side that an objection has been filed from the private respondent, and the department wants to file a reply. The prayer is allowed. The reply may be filed expeditiously.
Yes, my
The
lord.
matter pertains to 2023.
My
Should
lord.
not be
My lord,
pending actually,
Fix the
right?
date, my lord. My lord will fix the date.
Should not remain pending, for so long, isn't it?
Sometime.
Anyway, whatever it is, we'll
Yes.
I'll give it. No problem.
Sometime not before March, my lord, sometime after March, any day.
My lord, in April again, vacation will come. So let it be
April,
March,
my-
my lord.
Now we have a new interesting option, Saturday.
Yes.
You
Yes,
can
my
try.
lord. Yeah. Oh, that's even welcome, my lord.
We just had a.
March, my diary is full. If this honorable court can
No, no, it's
accommodate my
no
lord.
problem.
I leave it
You
to
want
my
it in March, no?
My lord.
You agreeable? March.
March, my lord.
My March, my diary
First
is, I'm not available most of the time.
So, okay, so you want it on? Given a
April,
choice?
any first,
April.
second.
Won't it be late for you? I can give, but if it's not late for you,
My lord will file it,
First, second.
fix in March, my lord. We'll see, my lord. If my senior is not there, then my lord, I will not harm of him.
I have my diary before me, my lord.
total full, huh?
It's full, my lord.
That's very good for you, actually, in a way.
April 1st also no problem. First, second, whatever.
My lord, April 1st.
The learned counsel for the respondent submits that she is professionally occupied in the month of March and prays for fixing it on 1st April. You agree reluctantly? But
Yes, my lord.
fix
I
on
have to, my lord.
1/4. I cannot write that. See, counsel agrees reluctantly. I can say
They're on
1/4.
those things, I understand.
1/4. But let's like.
My lord, now the problem is that, my lord, everything is online.
I understand.
So on you file your this thing, so we'll prepare, and before BU we can dispose it off.
My lord.
Whichever bench.
My lord.
Dispose it off.
I'm so
Should not
grateful.
remain pending for so long. No?
I'm grateful, my lord.
Bail hearing BA 14.
My please, my lord, this case, my lord, petitioner is behind the bar since the month of June 2025, my lord. Arrested on 10/4 to 10/6.
In this case, my lord, may can you peruse the order, last order, my lord?
Yes,
A
I am
report
seeing
was
that.
called for, my lord.
Hmm?
A report was called for, my lord, from the jail authority.
Oh, he was sent to West Bengal. That case.
That case, my lord, yes. That report is not received, my lord.
Why it's not coming? Otherwise, commercial quantity, right?
Commercial, my lord.
We have to see that 37.
But he is not directly, in fact, in court. Lordship may grant them time, my lord. I have no.
What to do then, but it's not coming. So, drawing my attention to order dated 27/1/2026, the learned additional PP, Mr. Ajay Burra, submits that the said report has not been received from the Superintendent of Central Jail, Kasar. The case map is also not received, right?
Yes, ma'am, this case ma'am received, my lord.
However, the case map has been received. You will retain it, like, you'll keep it.
No, my lord, it is in the scan copy of the record, my lord.
Oh. And stated to be, it is, that's, however, the scan copy of the sketch map has been received. And tagged with the remaining scan TCR. Full stop. Issue fresh requisition for a report from the Learned Jail Authority, right?
My lord.
If possible, my lord, next week.
You,
Let it come out after receiving the report, my lord.
better to fix a date.
Lord, we
I think,
fix
it's
it,
a
my lord.
bail matter.
16, my lord.
Looks
16 too.
Let us see.
Oblige.
15,
16.
May I please, Your Lord?
In diary.
Huh?
Nice. Well, item number 58, case diary not received.
Not received. 16/12, no, custody.
Hard date, Lordship, charge sheet has been filed, Lordship,
As per your information.
information, but I don't have the number and all.
Okay.
Charge sheet number we have, my lord. Charge sheet number
Yeah.
151/2025 dated 13/12/2025. This can be maybe called for, my lord.
It's not a bill here, regular bill, you see what, 51 days.
Well, the allegations are a little serious, so anyway, so we'll see the record, huh?
No, Lordship.
Only Learned Counsel, RJ, additional PP RJ Borwa. Full stop. The petitioner is seeking regular bail in connection with Hatigaon PS 126 of 25. He was arrested on 16/12/25. It is submitted by prosecution that in the meantime, case has been charge sheeted by CS number
151/151/2025 dated 13/12/2025.
Section 28. Some co-accused have been granted bail in this case.
Absolutely no idea.
No, I don't.
No idea.
I'm not sure, but the bails have come up, but I don't know whether it's the last order.
Section to be amended, you yeah.
So anyway, call for the scanned copy of the case diary as well as the charge sheet from the Learned Court Bill, which will be CJM Metro. It's list on
18 months. 18/2.
Not 13, Lordship, it's not Kamrup Metro only, already 51 days, Lordship. If that section 64 is not in charge sheet, Lordship, then I'll be
You want it on 13?
13 or 12, Lordship, any day.
But let it be on. Which will be better, 12 or 13? Friday. Okay, 13. Actually, though it is near, very badly overloaded, no? That's why everything.
Let it be on 18,
No,
Lordship.
no, it's okay.
No, 18, Lordship, 18.
I'm saying in a different context, 13, let it remain. The turnover, that means that despite the geographical nearness, this can be slow because very overloaded.
Much obliged, Your Lordship. Much.
16, 17,
Wait, please, your lordship. Lordship, in item number 16, lordship, there are three petitioner, lordship. Petitioner number 1 and 2 are on interim bail and 3 is in detention for last 41 days, lordship. Here FIR, lordship, will find on page 13, lordship. Allegation that, lordship, the informant while coming with her wife, lordship, to drop her in her residence, lordship, then his vehicle was obstructed by the two van, lordship, pickup van, lordship, for loading and uploading of that, lordship, because these petitioners' brothers have a, lordship, bricks and sand store, lordship. And in that regard, there is a quarreling, lordships.
Okay. That is not received.
Case diary received, my lord. Case diary received along with the injury report, my lord. Both the, my lord, victim, my lord, their husband and wife, they sustained grievous injury, my lord.
I see. Then what about?
And my lord, there are materials, my lord, against, my lord, this Ramzan Ali, my lord.
He's on interim bail.
The Ramzan is on interim bail.
On interim bail. Ranjan and Safikul on interim bail. Rahim in jail, lordship, 41. He was arrested on lordship 5/12, lordship 25/12, lordship.
Accused number 2 and 3 are interim bail.
But wrongly cut the one and two years.
Some mistake was there?
Yes, Lordship. Because actually that is against Lordship, one specific allegation against one, but the typing also Lordship probably.
No, no, the Ramzan Ali and Safiqul Ali have been granted interim bail.
Yes.
What is the mistake?
Lordship, it should be Lordship, Rohim and Safiqul Lordship. Ramjan,
Should
there
have
is.
been corrected.
Ramzan, my lord, there are materials against Ramzan Ali.
Mm.
Others are.
Anyway, he's got the benefit. There are materials against him. So grievous injuries also. May not be
Lordship,
justice.
since Lordship, they are in jail for some days, Lordship, and Lordship, after that, Lordship, no violation of the Lordship bail order, Lordship,
Oh, this is a BA.
BA Lordship. Already in jail, Lordship, and they were granted interim Lordship. Since they have not breached any of the condition, Lordship, let them remain on bail,
And
Lordship.
Rohim Ali was not given interim.
Rohim Ali, Lordship, what about Rohim Ali in jail, Lordship, in this case?
In jail. Actually, he
No
should have.
allegation,
Actually, he should have been given.
Rohim Ali also arrested, my lord.
But on,
Rohim Ali arrested subsequently, Lordship.
but on merits, it seems that it is not a very, at this stage.
Already case-
Lordship, may kindly say, my lord, the IRR petition, item number 17, my lord. In this case also, my lord, Rohim Ali is a petitioner, my lord.
Yes, what happened, Lordship, after filing of the anticipatory bail, Lordship, Rohim Ali got arrested, Lordship. That's why, Lordship, his name is struck off from that anticipatory bail, and he has approached regular bail in this case. So his name is in item number 16 as a petition number 3.
The materials there, what are the materials against Safiqul Ali and Rohim Ali?
Particularly, they were also there, my lord. They have also assaulted, but regarding, my lord, the grievous injury, my lord.
Oh,
It is as per the victim, my lord, it is caused by the, my lord, Ramzan Ali, my lord.
okay, so we can,
So he-
maybe we can consider for these two then.
My lord, that I leave it to your lordship, my lord.
And this may not be justified because, you know, though he was, it
My
was
lord, all
actually,
have, my lord, all
it's our
the,
mistake, of course.
all the
not
accused
yours.
person, my lord, they have assaulted, my lord.
All assaulted now.
Assaulted, my lord.
Those
But
specific against-
specifically against Ramzan Ali.
Ramzan, my lord.
Since Lordship is on interim, Lordship has not breached the condition, Lordship, Lordship can you consider? He will go
Let
for.
me have a look. Very grievous injuries.
Yes, yes, my
Head
lord.
injuries.
In head and my lord, they have also some spaces. It will be also there.
Whether Lordship, he has satisfied Lordship 320 of the.
So actually, the interim was granted, of course, we got wrong about one name. The interim was granted on some aspect of parity, I think. Though, I don't know how right we were, but anyway, it was submitted and on aspect of parity.
What happened, Lordship, in the, though previous art, Lordship, whether she has been admitted for last 20 days.
Who
my lord,
accused
that has
Abdul
been
Rasid
seen,
so and so.
Lordship.
These persons, Abdul Rasid Ahmed, Rahmatullah, Rahmat Ali,
But they were also, their allegation is that they all have assaulted, my lord.
all of us.
But specific allegation is against Ramzan Ali, my lord.
Lordship will say, appreciate one thing, Lordship, though all these are the brothers, Lordship, they are unnecessary, Lordship, named in the affair, because Lordship, they have a sand and brick store, Lordship, that's why.
They made video also, according to the forwarding report. Nowadays, this is a new, kind of
New kind of-
perversion. And they are not scared also to make video. People are not scared also to make videos of wrong things. Anyway, I think, so, 8-1, no? The first, that's 2, 3. 3 paragraphs. Same, that's true. That's true. The petitioners, Ramzan Ali and Safiqul Ali, out of the 3 petitioners hearing, there are 3 petitions. There are 3 petitions were granted interim bail on 8/1/26 on some aspect of parity with regard to such interim granted to some 3 co-accused, 2 co-accused. But so, however, they said interim was granted in a pre-arrest bail application. It was slightly wrong, actually. Mr. Chaudhary Learned Counsel fairly submits that perhaps the interim bail was meant to be granted to Safiqul Ali and Rahim Ali. Petition number 2 and 3 herein. Nevertheless, it is submitted that after being granted bail, they have not violated any conditions and praised for making the bail, interim bail absolute. The case diary has been received. Apart from the bail objection, strongly contending to rejection of bail, contending for rejection of the bail by the IO. It is also submitted by the learned additional PP, Mr. Borua, that though the investigation has stated about all the accused persons assaulting, but the main implication about assault is against Ramzan Ali. It is also submitted that the materials have found that both the husband and wife were victims. The husband was the informant.
Yes, Lordship.
Yes.
Both the husband within bracket informant and the wife who are the victims sustained grievous injuries. In my considered opinion, given the above facts and circumstances, it may not be prudent to grant bail to Ramzan Ali at this stage. So accordingly, the vacating his interim bail, his bail petition is rejected. He shall surrender before the learned court below within 7 days, full stop. However, the interim bail granted to Safiqul Ali alias is hereby made absolute. And the further, petitioner Rahim Ali is allowed to go on 25,000 advance. So the following bail conditions are imposed for both of them. Number one, they shall cooperate with remaining investigation, shall not hamper or temporary evidence, shall not intimidate, harass or harm the informant / victims in any manner. They shall not misuse their liberty to commit any illegal activities and offences. Good stuff. The bail petition stands partly allowed on the aforesaid terms. Return back the case then.
Lordship, regarding Ramzan Ali, Lordship, he is suffering from mental problem, Lordship. That's why, Lordship.
Then we'll see another occasion after. Let him, because it was incorrectly given in the first place actually. Secondly, materials are also there. Anyway, 17 is what?
17, Lordship, 1 and 2, Lordship. Is only.
Oh, the other three.
Other three, the 3 was struck off. And 1 and 2 is granted.
So this is also same that the assault allegation is there,
They are all.
but implication against Rahim Ali.
It's Ramzan Ali.
Ramzan Ali, sorry. Again, I'm going to go. In view of the aforesaid facts and circumstances, perhaps it may not be essential to cancel the interim bail granted to the petitioners. Petitioner number 1 and 2. Accordingly, same is made absolute, subject to the condition that same conditions.
Highly obliged. The medical ground that, Lordship.
Medical ground
of the suffering, Ramzan is mentally disordered.
I think it will not be justified at this stage, whatever it is. You can file later with some medical documents perhaps.
Though, Lordship, he is in jail for 33 days, Lordship, that time, Lordship.
So anyway, so he can let him take treatment. No, it will not be proper in my view at this point.
Obliged, Lordship.
Yeah, please. Lordship, affair is on page 13. And Lordship, my case is that I have a photospect or I am a photographer and I am not name accused. Name accused Binit Bardhan has used my photography skill and photography institution for editing something, maybe. And that's why I am implicated as the accused during investigation. Lordship, I have completed already 20 days. I have already completed 20 days in custody.
20 days. What is the allegation?
Allegation is not.
Diary has been received.
Like is very received, my lord. Lordship may kindly produce the FIR, my lord. The FIR is very clear, my lord, from first paragraph, my lord. That I hereby inform you that we had received a copy of a domicile certificate dated 13/12/2025 in the name of Barbie Terror, care of so and so, resident of so and so,
Yes, fake.
which has been verified from our office and as forged and fake, my lord. Now, my lord, during investigation, my lord, one person has been arrested, my lord. His name is Binit Bordhon, my lord. Binit Bordhon.
Binit Bordhon.
Bordhon, my lord.
Acha.
He, my lord, he prepares, my lord, all these fake and forged certificate, my lord.
Okay.
And he sold to, my lord, different customer, my lord, and he is operating a racket, my lord.
Acha.
Now, my lord, the role of this present petitioner, my lord, Biswajit Dey, my lord, he got a computer shop, my lord. Now, my lord, the certificate, my lord, it was, my lord, forwarded to him, my lord, by this Binit Bordhon, my lord. And he, my lord, edited the certificate, my lord. This is the allegation against him, my lord.
Lordship, that Binit Bordhon.
He edited the certificate.
He edited, my lord. Actually, my lord, he prepared the certificate by Binit Bordhon, my lord. Then it was sent to, my lord, the computer shop, my
And
lord.
he's a photography shop.
Photography, computer photography. In his computer, my lord, he edited, my lord, the certificate, my lord.
Okay.
And thereby, my lord,
He may not know also that it's fake.
but that is not clear, my lord.
That's
Because the
not clear.
conspiracy part is there, my lord.
That's not clear.
Conspiracy part is there, my lord.
He may not know, he may, no, that's what, if he's not, if he does not know, then he's a victim of circumstances. If he knows, then he may be part of
No matter it is
conspiracy.
from the case that it is not clear, my lord,
Not
that
clear.
he does not know any, my lord, the intention of the, my lord, main accused person.
Lordship, Binit Bordhon introduced himself as a government employee and so is a card, that's why.
Mr. Sharma.
Yes.
Yes, Sharma, learned counsel. Invoking 483, the petitioner is seeking bail in connection with Okisto PS case number 14 of 26. He was arrested on 15/1/26. The petitioner is stated to be a photographer, is having a photography shop. Photographer having a photography shop, full stop. The case arose out of an FIR dated 31/12/2025, lodged by Circle Officer, Dispute Revenue Circle, alleging issuance of fake domicile certificate. Full stop. During investigation, what Bordhon?
Binit Bordhon.
Binit Bordhon was arrested and alleged to be running a racket regarding the same. Learned additional PP fairly, Mr. Borua fairly submits that the materials found so far against the petitioner, present petitioner, Biswajit Dey, is that he edited one of such certificates was sent to him and he edited the same. And that it is not clear whether he did it as part of his business work, routine business work, or he was complicit in any illegal acts with the arrested accused person. In the given facts and circumstances, the case diary may be returned back and procured again for the next date with updated investigation. However, in the meantime, in the interim, the petitioner is allowed to go on bail of rupees 25,000 with one security, subject to the satisfaction of the concerned learned court, and subject to the conditions that he shall cooperate with remaining investigation. His statement must have been recorded already, but he shall.
One line may be edited, my lord.
Yes.
He has not only edited one, my lord, 2, 3 copies.
And
my lord.
he's
And
edited some of those certificates.
And in exchange of money, my lord, that is also his statement, my lord.
That is his work.
Yes.
That can be bad benefit of that
Yes,
can be
ma'am.
given. But that's why let him cooperate with the remaining investigation, and if necessary, appear before IO for further examination. He shall not hamper or tamper with evidence and not commit any legal activities. You can give it some time. Let the investigation
Let
proceed.
it be on 25/2, my lord.
26 to
26.
little bit later.
Highly obliged.
26 to.
19.
There's another one, no? Sorry, wait over this.
May I please, my lord?
Yeah.
My lord, here arrested on, my lord, 10/11. Today, 87 days in custody. my
Yes,
lord.
yes,
This
yes,
is
ma'am.
second bail application, my lord, earlier rejected by your lordship.
Miraj, what is this
My
matter?
lord, FIR is at page 30, my lord, 30.
It's 30.
Yes, ma'am.
That he has received, no?
Is that received, my lord? Earlier rejected, my lord. Lordship may kindly peruse the rejection order, my lord. That will be convenient for you, lordship.
Because
Page number
that,
34. my lord.
e-rickshaw matter. Hmm?
E-rickshaw, my lord, what?
Item 20
is also connected, lordship. That can be taken.
Page 30 FIR.
Okay. If investigation has progressed, he can be considered.
My lord, investigation has progressed, my lord. Only the, my lord, final cause of death has not been received, my lord. Postmortem report has also received, my lord. And
PM report has
regarding
been-
materials, my lord, if lordship has already rejected, my lord. There are sufficient materials, my lord.
Oh, yeah,
collected by
that,
the IO.
1812, yeah, there are some materials.
Yes, my lord. 1812 it was rejected.
Let me have a look.
See to the 87 days, my lord.
Page 34 level. Our order. Mr. Gupta fairly submits that this is a subsequent petition and earlier petition was rejected on 18/12/25 in BA 4025 of 25. So Peruzam is there. Definitely 1, 19, 39 days or 87 days.
87. Arrested on my lord 10/11/25.
Second paragraph, second, third, fourth paragraph. The learned additional PP, Mr. Borua submits that the investigation has revealed implicating materials. However, investigation has progressed, though final opinion regarding the death has not yet been received. The postmortem report it is pending for viscera.
My lord, yes.
Viscera.
Viscera.
Viscera is needed only in case of poison, actually. Poison or
He was assaulted in public, my lord.
very unfortunate incident, actually. Anyway. The postmortem report is available. Mr. It indicates injuries noticed on the dead body in the form of abrasions, contusions, etc. Including on the temporal region, frontal and temporal region. Hemorrhages. And hemorrhages. Hemorrhages also noticed. Despite the adverse materials, considering the length of detention and the progress of investigation, perhaps the accused can be granted bail at this stage. In the subsequent petition, according 50,000 with one security, the satisfaction of CGM Tinsukia, and subject to the conditions, number 1, cooperate with remaining investigation, not hamper or temporary, shall not in any manner intimidate or harm the informant side and their family members, shall not try to intimidate or influence witnesses. Violation will entail cancellation of bail. Return back his diary. Bail petition stands disposed of.
My objection may be recorded, my lord.
Yes,
It was
the
earlier
learned,
rejected.
summing up the submissions, the learned additional PP contents that despite the length of detention, considering the materials, bail may not be considered at this stage.
My lord, much obliged.
20,
20 is also connected, lordship, arising out of the same FIR,
Same.
lordship.
Rejected, earlier rejected on the
Length of
same
the-
day, my lord.
Length of detention, same, lordship, 87 days, lordship.
Oh, I remember. Thank you. What you call it?
Rejection order, lordship will find at
Yes.
page number 65,
Two.
1812.
On same. This is two can be page 65, the order. And same conditions. Return back his diary, bail petitions allowed in.
Obliged, lordship.
55,
Have to see the RNA.
Please, your lordship.
This is the second bail application, my lord.
Bail objection has been filed by prosecution.
Yes, my lord.
NCB, Mr. Chaudhary.
Lordship, yes, Lordship, in fact, I am appearing for NCB from today. I just
Okay.
received the papers.
Good, congratulations.
The ground is on, there is only one ground, my lord. Violation of section 48, my lord. BNL.
Otherwise, it is commercial quantity.
Commercial quantity.
I think, Lordship, that has been taken into consideration by the earlier order passed by the Islamic court.
Nice.
Page 19, paragraph 9, my lord.
21/11/25.
I see. Let me see. This aspect was not, the
Here it is.
notice aspect was not gone into main contentions
Yes,
or
my lord.
notice. So no, I have.
According to them, my lord, the notice was served to the father of the petitioner. And I have annexed one autopsy report. Your lordship will get it,
You comply.
annexed D page 21.
Just a minute. No? See, actually, the 37 was not gone into, but this aspect was gone into. The
Lordship,
notice aspect was gone into.
yes,
The previous order
yes.
in para 10, kindly see. Previous. I
I've got some few papers. I do not have
Acha.
the pictures also.
kindly help him with this. In the, rightly or wrongly, I held that there has been compliance with 47 and 48.
Yes,
So I cannot revisit the same, right?
yes.
Unless there's some subsequent grounds, but notice is a fixed matter no, on that basis.
Yes,
Unless
that
there's
is-
something, because I cannot review. So 37 we have not gone into actually. At that time, it was at the stage of investigation.
Lordship.
So without going into 37, it was rejected because it was at the stage of investigation. Now, if merits has to be seen, then we have to go into 37. But as regarding his new contention, that notice aspect, on the same materials, I will not be able to revisit. If there is something else
That is what.
that we can look into,
His
otherwise
submission is that notice only.
you have to, knock the doors of higher court.
His submission is with regard to notice, Lordship.
No. So as I said, no,
Only section 48. my lord.
we can always be wrong, but whatever it is, rightly or wrongly, I held the discussing, however,
Sorry.
that it was complied with. It was given in Hindi, explained to the father or something is like I've discussed.
His father expired prior to the date of incident.
Okay, is it?
Yes, my lord. I have annexed the autopsy report. my
No,
lord. Annexed
then-
D
then
page
we can
21.
see that. Then
How
we
can
can
this
see
serve,
that.
my lord?
Which was given to the father, another document is also available in telephonic. Which is, that's interesting, then let's see that. I have always said they should, if compliance is there, fine. If it is not there, I'll learn next time, but no manipulation. That is always better. Can you show me the relevant part?
Yes, my lord. Your lordship has kindly saved annexed D page 21, my lord.
This will require some 21.
Yes, my lord.
You must have the full file, Mr. Chaudhary, isn't it?
Lordship, today I do not have. Lordship.
You'll need it, you'll need the, anyway, I'm seeing this,
Yes.
but if necessary, we can adjust it for a day or two.
Yes.
And then, let me see this document, however,
Yes.
page 21.
21, annexed D, my lord.
21. Okay. 23-2.
Yes, my lord, he expired. Now your lordship kindly see the FIR, my lord, page 11. FIR was lodged on 12/7/2025, my lord.
And what is the, do you have the 48 notice here?
I
You'll
don't
also
have
need to
because
see
it
this
never served on me.
record also.
If your lordship can have it on 13th or so, lordship, I will get myself.
We'll have to adjust. Date will work it out. But see, there's no review jurisdiction, right?
There is no.
There's no review jurisdiction, but will this be a subsequent ground? Can this be called a subsequent ground? That this was not there? Because we cannot do indirectly what we cannot do directly. We cannot review, right? Even if it's proved that I am wrong, suppose, then I cannot review,
No,
unfortunately.
it will, lordship, if the records, I'll be very fair, lordship, if the record
Indicate that it was different position,
reveals otherwise,
then maybe subsequent ground. It can be, that is his contention, I think. No, that is
Yes,
your
yes,
saying.
but so far as the objection is concerned, if my lordship will come to paragraph 12 of the objections, states, I'll just read out, your lordship.
Of your objection.
Yes, lordship. The averments made in paragraph 7 are false, misleading and denied. The petitioners claim that because his father had expired earlier, therefore no notice was issued under section 48. BNSS is legally untenable and factually misconceived. Section 48 BNSS requires intimation of arrest to a relative friend nominee as per procedure. It does not render the arrest illegal merely because intimation was addressed to one of the family members or because the accused later asserts that such person was not alive. The record already contains service for grounds of arrest to the accused under section 47 BNSS with his signature, written intimation under section 48 BNSS, document recording telephonic intimation to a relative, and intimation to the officer in charge of the concerned police station. The petitioner himself acknowledged the documents on 12/7/2025.
No, if it is,
If there is something in the record, maybe.
then we'll have to see. If it is to another person, then certainly.
If they have served to another relative,
Then it's okay.
then it's okay, my
Then
lord. I
it's
don't have
okay.
any objection.
Then it will
But
be
to
saved.
whom they have served.
If this, if
Whether
they have
they have
served
any
only
receipt
to
or not.
father, then and he was, if there is clearly this you can bring the original death certificate also on the next day.
Lordship.
He can bring. No, they have submitted.
Yes, yes.
You can. You have annexed with this bail petition, right?
Yes, ma'am.
You can have it with you, the original one also. That will help because then we'll say that. If the different fact comes to view, comes to light, then
Definitely.
it can be a subsequent
Definitely.
ground, maybe. Yes. So give him furnish him a full set. Record is already here. So Mr. RKD Chaudhary, learned appears on behalf of the NCB. He may be furnished with a full set of the bail petition.
Yes.
Full stop. The scan record is already available. The main contention taken by the petitioner in this subsequent petition is that notice under 48 was shown to be furnished to the father of the petitioner. But relying on a death certificate, it is contended that he expired on a date prior to prior to the date of registration of this case. Because this is a very important matter because you are bypassing 37. If 48 is relied upon, you are bypassing a very strict law like 37.
Yes.
So that, of course, we trust him, of course. The thing is that, for procedural propriety, that document has to be properly,
Yes.
list. And if necessary, it may even require a verification from the IO or
Yes,
something of that sort. So we'll do it next time.
Yes.
Now, no need. We'll stop.
I think my lord, TCR is available, my lord. I think.
No, TCA, this we'll see. No, the date record, date petition, the date certificate may not be
Date
available. in
cert
the-
is not in the. TCR.
Because you have submitted.
Yes, my lord.
You may submit it before IO, he can
The other
verify and
people are-
submit a report.
whom-
Should I pass an order like that?
If
Or
your
not,
lordship,
on
that
the
would
next
be
day,
that would be helpful for.
helpful to him. Should I? The petitioner side is at liberty to,
My lord, only one thing, my lord. If it is served to someone, my lord, it can be revealed from the record, my lord, to whom they have served.
that we
Record
can
is
see.
available.
No, date certificate, this one.
Oh.
Because it is not served to anyone.
Anyone.
And then father is clearly dead. on the basis of a bona fide certificate.
According to them, they have served to my father. That should be in the record, my lord, whether it is
No.
served or not.
So this is there, but that
With receipt, my lord. With signature. It cannot be there.
that we'll have to see. Anyway, we'll just, today I'll not pass the order. If we have problems with the the certificate, then we'll call for a verification. It would have saved some time, but anyway, as you wish. So list the matter again on.
If it is not inconvenient, can it be on 13th, Lordship?
Third.
313.
Oh, 13.
Okay. Otherwise, even without the order, you can
Yes, yes.
take it before the IO.
Copy from my friend.
Even if you, without order, you can.
Yes. Okay.
Or should I observe that he is at liberty to
That
go
will
before
be
the IO?
more
Just
helpful.
have him, my lord.
Okay. No, the death certificate.
That's it. Yes, madam.
The petitioner side is at liberty to place the original death certificate of the petitioner's father before the IO of this case, who shall verify it and submit a report to the prosecution. You are at liberty. I'm saying,
Yes.
I'm not compelling you to liberty.
Oblige.
Short break.
Fifty-two, also we have received the instruction that CS is pending.
Hmm?
CS is pending, so it is not.
Yes, is pending.
The order copy is earlier.
এইটো আপোনাক দিছিলো নেকি? এইটো আপোনাক দিছিলো নেকি মই? ৰাখি থৈছো। ঠিক আছে।
Other persons will get bail, lordship has the order.
Yes, chamber. Partly dictated, last part. Chamber.
Lords.
He has to be allowed
Lords.
under similar grounds.
56.
Please, your lordship. Is there you was call for law?
Yes, there is a lordship.
Okay.
He is a named accused lordship. He has been named in the FR killing of the
12, no?
son of the
After
gunman. Some quarrel was there as per the allegation of the FIR, and they have sustained to his after he was taken to hospital. Is that case, no? My part is that lordship, I am one of his friend, lordship, one of the best friend. I used to visit his home and I used to drop him, lordship. On that day, lordship, some other incident happened, lordship, that might reveal from the case diary.
Just a minute, no?
Lordship.
The complainant's son.
PM report আছে?
PM report pending আছে।
ওই PM report আহা নাই।
Opinion to pending আছে।
Opinion.
The petitioner also FIR named.
Lordship.
Yes.
There are
There are only one petitioner.
Oh, one, lordship. He is the number one, lordship, in the.
Oh. Anyway, whatever it is. Materials.
Lordship, mobile, for the PM report opinion regarding the cause of death is kept pending till the receipt of the visa.
No, but again, it's a allegation of injury, so we can see from the.
One injury here also. Multiple needle puncture marks seen over the cubital fossa area.
Hmm?
Multiple needle puncture marks seen over both cubital fossa area. Cubital fossa area is this part of
He is a
the.
drug addict, lordship. The self-injected, lordship. He is a drug addict and self-injected and.
And after the incident, a video was sent to the family members of the disease lordship. And that video, the petitioner and other persons assaulted the disease lordship. It is just clear from that video lordship. It was cleared up. From the 81 of eyewitnesses also there. Some of that witnesses that they have interpreted the petitioner 1 year lordship. It's in Bengali lordship. He has stated that বিশেষ করে ইকবাল হোসেন, this petitioner, Dilu,
You can read it.
লর্ডশিপ বিশেষ করে ইকবাল হোসেন এলিয়াস দিলু দিস petitioner বেশিরভাগ হাত দ্বারা মাথায় নাকে মারে একসময় সাদিক মাথায়
Mafia, he has hit in head and nose and at face, Lordship.
And he was a drug addict, and secondly, Lordship, the ground that no notice was served upon us, Lordship. That can be looked into the case, diary, Lordship, because we cannot,
This
authentic.
statement of the eyewitness, Lordship, this can go for the 180.
Otherwise, on merits, looks like a little tight at this stage.
He's a drug addict, Lordship, not because of that injury, Lordship. He had overdose and some. দেখা পাইছে ভিডিঅ'ত ফটো আছে আৰু নাচিব গ'লে কি কথা ভিডিঅ'ত ফটো ওলাইছিল
Videos viral.
ওলাইছে আৰু কৈ নাছিল
It is not here, they are not there.
এটা কাম কৰো এই ৰিপৰ্টটো কাৰণে মাৰা জানে মৰিছে নে ড্ৰাগছ অভাৰডোজৰ কাৰণে মৰিছে ৰিপৰ্টটো কাৰণে
Is an illegal drug trade near
Yes.
the track, and
That-
incident is related to that track.
That track.
They were beating him because he was a drug peddler or something.
Oh, Lordship, some incident,
Some con-
unwanted incident occurred, Lordship.
He's
as
a
per
dead
the-
person now. We should not
Lordship,
stay
regarding
there.
some sexual assault to a girl, Lordship, that part has been there. How far is
Regarding
it-
that drug trade, the confrontation took place between the disease and the persons. Lordship.
In this 164 statement of Abdul Sohid, the present petitioner's name is not there. I think.
Maybe he cannot identify the name, but one witness is there.
And some others.
Some others. But one
He
witness,
named the persons he knew.
yes. And one other witness is there, he has identified this petitioner. Lordship.
Co-accused, what did he say? Co-accused statement?
Co-accused are not yet, statement is not there because they were not apprehended, I think. Going to the case there.
One more is there, Lordship. Lordship will find one Yasuddin, Lordship. 2% were arrested together.
Yes. Yasuddin, he has mentioned this.
Lordship. 62 days. Is it? What is it? Fifty days in custody and father the notice part.
60 days. Notice you have seen, check.
Have to take it.
Arrest, present times arrest should follow all this, there should not be error. This error.
না না দিয়া নাই notice দিয়া নাই বুলি কৈছে এতিয়া মানে আমি পুৰা স্পেচিফিক ক'ব পৰা নাই যে দিও কেতিয়াবা দিয়ে নিদিয়া বুলি কয় আমি এখন চালে ওলাই যাব
Notice join a late phase.
এই আজিকালি বিচাও কৰি দিয়ে মানুহবিলাকে সেইকাৰণে বেছি
Prior to the incident, all along the petitioner was with the disease. Lordship.
Hmm?
Prior to the incident, all along the petitioner was along with the deceased.
No, that is admitted fact. Lord. He is one of my close friends. Lord.
Oh,
That is the admitted fact. Lord. I picked him, Lordship, from his home.
yes. I don't know actually. The exact cost to be determined, postmortem. We can keep it pending also for some time, that is also one option. Get the opinion
Final
regarding
opinion.
that,
Final opinion regarding that.
or we can dispose it off at this stage. But
62 days, Lordship.
looks little tight, and notice you said, notice. Could you see the notice part?
Notice I have not gone through, I have checked it out.
Go through it after some time. Or maybe.
57.
Lordship, this way the petitioner is behind the bar from 15-8, my lord. The fire at page number, my lord, 10. Comparative page 12.
Page 10.
Then operative page 12.
Yes, yes, yes.
I so and so
He was arrested on
15/8.
15/8,
8.
long time. She already charged it.
My lord, kindly have it.
But the case that a lady was
Yes, yes.
No, already at a.
Yes, yes.
My lord, charge sheet start from page 17, my lord.
Right.
Page, lordship, 32 may kindly quote you.
Has trial started? No.
Started from,
Started.
my lord, or let's scan copy received, my lord.
can copy received was charged submitted on lordship 31/10/25.
Acha, okay.
They are 31/10/25 lordship.
Now, my lord, page
I'm on page 32.
32, my lord, paragraph 3, my lord. During the course of investigation, visited the place of occurrence and draw up sketch map of the place of occurrence, examined the complainant and available witnesses, and recorded their statement under section so and so. Crime scene officer SI so and so also visited the scene of crime and seized in presence of witnesses all the suspected articles found near the body of victim so and so with mobile phone number so and so so and so. During CDR analysis of mobile number of victim so and so, a suspect with mobile number so and so was identified by unusual number of calls and call duration of a day was when victim was missing, and also there was a transaction of rupees 3,000 which was paid by victim to the suspect of the on the day of occurrence. On further examination of the complainant and other witnesses, there was a strong reason to believe that the suspect having number so and so who was identified as Stephen Hans was involved in the commission of crime. Later, with the help of the villager, suspect named Stephen Hans was apprehended and no further examination, and on further examination, he confessed before the police about the commission of crime and also told that there were 4 other accomplices who helped him in such and so. Here he took name of the petitioner, my lord. Subsequently accused Stephen Hans and other 4 accused so and so were arrested. Now, my last paragraph, 4 accused person, namely so and so, the coordination together with, then with the help of Stephen, they plotted to kill the so and so. In his statement under section 100, Stephen stated that he has committed murder of so and so on the direction of 4 accused person, namely so and so, also paid 3,000 rupees, my lord. My lord, he may have some problem. He is also an employee of the, my lord, LNT, my lord. And he murdered.
The present petitioner is, who's he?
My lord, Ravindra Singh Rana, my lord.
Ravinder Singh Rana. What is the stage of the trial? That is very important. How many, otherwise that is the only consideration. Important witnesses, whether examined.
No, ma'am.
At
How
this
many
stage,
exam-
next day is 16 to 26 for evidence.
No PW have been examined.
Not examined. 16 to is the next date. Charge framed on 3/1/26.
No, because there have been, there's no doubt about length of detention. It's on the higher side.
My lord, everything was
But,
recovered from Stephen, my lord. And he is the main accused,
No, he was a allegedly contract killer.
my lord, for 3,000 only. my lord. Can it be believed?
Unbelievable, but sometimes
My lord, he is the
not impossible.
petitioner before your lordship,
This
is an
country.
employee, my lord. And he, the main accused, my lord, he is involved, my lord. Everything was recovered from him, my lord. And during investigation, my lord, he took the name of the petitioner along with.
But what
other-
is the, there has to be a motive.
Yes.
My lord.
What is the motive? There, in this kind of cases, motive has to be there. Anyway. Earlier bill petition was rejected. Subsequent bill petition, as an earlier bill petition was rejected by this court.
No, it was not rejected by
Huh?
first time.
Oh, this is the first time?
My lord.
Sorry.
If lordship is not considering my case, then my lord, it may be posted after 16.
Stop. এইটো দিলে নহয় আমি হেৰি এইটো উমৰাংশু পিএছ কেছ নাম্বাৰ 17 of 25 তাৰে আমাৰ ফেক্স খিনি লৈ ল'ব। the Mr.
Jealous.
The learned counsel appearing for the petitioner submits that this is his first bail application and he's in judicial custody since
15-8 now.
his last 50 days on his arrest on 15/8, so it's
15/8/25.
not 50 days, since 15/8/2025. Full stop. The scan record has been received. Other co-accused are also in custody. Right? Stop. Yes, sir.
Your lordship, in the morning, I made a mention, your lordship, for unlisted,
Yes, sir.
arising out of the same.
Same matter. We'll take it up. Here. What is your submission, Mr. Goswami? The case has already been charge sheeted and
Already charges paid.
registered into special case number 4 of 2025.
Because
As the provisions of SC/ST Act have also been added, full stop. Such, it appears that charges have been framed and case is posted for evidence on 16/2/2025.
26.
26. It is submitted that prosecution evidence has not yet started so far. Who is the petitioner in the other case? Your petitioner?
Oyan Chaudhary, your lordship.
Ayan Chaudhary. He's also in custody.
Your lordship, he was also in custody for a time being, he was allowed bail, your lordship. After that, he again surrendered.
Again surrendered. In my opinion, let the evidence.
Some witnesses may be examined.
Just he's also arrested on the same day,
Your lordship, he was arrested on 17th, your lordship.
17th.
17th of
August.
August 8, 73.
Ayan Chaudhary, 17th of August. The file has not come, no? Only.
Yes, your lordship, that may be the
Record
copy may
will
be
stay.
retained, your lordship.
Out-
Copy may be retained, your lordship, but F2 may be
Yes.
taken, your lordship.
Okay, no problem. I'll not, I do not like it. Okay. We can wait how, dot. After hearing that, we'll dictate together. Or inside. Otherwise, the learned additional PP contains that the bail may be considered after examination of some important witnesses.
Independent, my lord, may be fixed after, my lord, evidence, some of the.
Hmm.
Otherwise, my lord, going by the charge.
Let him hear,
my-
because since he has filed new,
Lord,
at least is preliminary contentions. After two,
Lord.
after two.
May it please your lordship. FIR, your lordship will find at page 9. He is in custody since 16/1/26, lordship.
Yes.
There was an accident, lordship, and regarding that accident, this FIR was. And initially it was registered under section lordship 106, but subsequently lordship, by paying to correct the same lordship, they added 105 instead of 106 lordship. And because of that, I am in. custody,
Homicide.
lordship. Yes. And for correction lordship, that they have filed their application also, no specific reasons was mentioned in that application lordship.
As I say, this is an emerging area. Mechanically, homicide section should not be given, and I think that will be a distortion of law.
Lordship.
But
Because
it is
initially-
also true that if there's gross negligence, sometimes it can be, it can get transferred to the domain of homicide also.
That also lordship, that 302 earlier, the part 2, lord, 304 part.
Part
two,
it
I
will,
asked for that.
It will be part 2. Knowledge.
Knowledge.
Actually.
Intention is not there. So that 105 admittedly is not coming up.
105 is what? Murder.
Yes, culpable homicide not amounting to murder.
Okay,
That is
no,
earlier,
that-
earlier 302.
Okay, and, okay, 30, earlier, no. 105, right?
Punishment for culpable homicide not amounting to murder.
BNS.
Yeah.
No?
Earlier 304 part.
Part 2.
Part 2.
Part 2 might come sometimes. But that intention and knowledge that. No, intention may not be there. Suppose, in a crowded street, suppose if somebody gross negligence, then it becomes. The highway. Then it becomes, it crosses the boundary of negligence and goes into, homicide with knowledge. But not necessarily intention. But if it is within that speed limit, then it will probably not count. So those things those are matter of trial. Anyway, you are arrested on 16-1. Because lot of, there's people, lot of reckless driving also, I don't know. In fact, that 106, that a non-bailable clause has been stated by our Honorable High Court Lordship Division Bench. Therefore, probably they inserted section 105. Which non-bailable? 106 part 2. That is non-bailable in the present Act, Lordship. And that has been stated by a Division Bench of our High Court. That order is also there. 106 pertaining to that truck drivers. If he runs away from the place. Oh, that was put on hold. Yes. That was put on hold. Because of that reason. That was put on hold. Yes, because of probably that reason, they have added 105. But although 106, 1 is also there, it is not stated by this Honorable Court, Lordship, for rash and negligent. The price of, negligent driving is terrible. Lordship. We all know, Lordship, that I'm not. That is no doubt. It's okay. You're doing your professional duty. Lordship. None of us are safe. Anyway, let us see this.
Postmortem accident took place also because and the witness said that the injured person said that the petitioner was driving the vehicle in a very high speed also. And the statement of the petitioner also said that they have in a high speed and hit my vehicles.
Who?
The petitioner. In his statement, he said that they have run the vehicle in a very high speed and hit his vehicle. And the injured person also said that yes, he ran the vehicle in a very high speed. That's why the collision was took place and the vehicle is fully damaged. What we can control the statement of the injured person also and the witness also.
And I have stated the fact at paragraph 5 of my petition.
Due to that accident, he has sustained head injury. That's why circumdeath was.
Injured come driver of the victim vehicle.
Driver of the victim vehicle? Yes, that is the statement of.
You said this. Petitioner also sustained injury and therefore the trial court Lordship directed the jail authority to give him proper medical treatment, Lordship. That is also there in my petition, page 21.
Yeah, last but the petitioner statement also.
Where? Last, your petition, page number? Page 21. In middle portion, your Lordship will get the jail authority, district jail. Filling over right hand and conclusion. No, but, It's appears to be a head-on collision,
collision.
head-on collision.
Lord.
Anyway. Third A. Ahmed Land Council, DP Goswami, 483 BNSS, Dhemaji PS case number 13 of 2026. For the petitioner was arrested on 16/1/2025.
26.
Also, you have written wrongly. I also,
I'm sorry.
16/1/26, it's wrongly typed. Anyways, obviously. Based on an FIR dated 15/1/2026, lodged by Deepak Kumar Sharma, with the allegation that in the morning his elder brother Brajan Sharma and Tiju Munda were proceeding on a Mahindra Jeto vehicle. And on the way, the vehicle AR01L0945 coming from opposite direction in high speed and rash and negligent manner collided with the said vehicle, whereupon the driver and informant's elder brother sustained injuries, and the informant's brother died. Full stop. The case diary has been received. Full stop. The Mr. Ahmed Learned Counsel, drawing attention to an order of learned court below, submits that in the accident, the petitioner also sustained injuries. The statement of the driver plus victim driver, one of the victims, namely Tiju Munda, is available, in which he has stated about the vehicle coming from the front side with high speed and in a careless manner and hitting their vehicle. I've seen the progress of investigation. The learned additional PP fairly submit that in his statement, the petitioner accused states on the contrary that it is the other vehicle which was coming with high speed. So it is submitted by prosecution that though the petitioner, though the driver has stated on these lines, but from the overall materials, it's not clear as to whether so far as to whether it is a case of, can I record it? Or whether it is case of mere negligence or homicidal negligence. Or negligence graduating into or a case of culpable homicide not amounting to murder. Full stop. The aspect of negligence vis-a-vis culpable homicide not amounting to murder was gone into by the Honorable Supreme Court in the case of Elista Pereira versus State, citation reported in ... The relevant paragraph may be reproduced here in below. Next paragraph. Road accidents are a highly avoidable human tragedy, leading to death and disability, and extracts great financial, imposes great financial burden on families also. However, on the legal perspective, some accidents may have elements of gross negligence, which can be said to graduate into the domain of culpable homicide, not amounting to murder, with a comma, especially one attributed with knowledge. Full stop. However, all accidents would not usually be in the said category, and many of them would be many of them could be cases of causing death or injury by gross and negligent act punishable under so and so sections. 338, 338, 304A IPC, now and so BNSS. Despite the terrible human tragedy that accidents, especially serious accidents, that are, nevertheless, the police authorities at the time of registering such cases to prima facie look into this aspect as to in which category the accident falls into from the point of view of penal law. Full stop. Any mechanical application of penal provisions pertaining to homicide in accident cases will dilute the case of those accidents where there is a genuine element of culpable homicide not amounting to murder, especially attributable with knowledge. In the instant case, the accident appears to be arising from a head-on collision. Full stop. Prima facie, there appears to be some negligence, though it is not clear whether there is also contributory or composite negligence on both the parties. Full stop. The aspect of homicide would be a matter of further investigation. Considering the length of detention and also the progress of investigation, I have the considered view in the aforesaid facts and circumstances, and also considering length of detention and progress of investigation, I am of the considered view that the petitioner can be granted bail at this stage. In such view of the matter, the allowed 30,000 with one surety to the satisfaction of which court? Learned Chief Judicial Magistrate CJM Dhemaji. And subject to the conditions that he shall cooperate with remaining investigation. See, he shall not hamper or tamper with evidence. He shall not commit any illegal activities. Actually, I feel like saying that he'll drive carefully. But it's not a usual bail condition, but we should do something, even our court, because this has become 500 people die every day in road accidents in India, and more than 1,000 are maimed. That day I had to go for some medical emergency. One boy was brought. I'm granting bail. It's not that I've been influenced by this, but see, it can happen to anyone. None of us are safe. One boy, he was hit by a dumper in Narengi, and his skull had gone inside. And his doctor was repeatedly saying that the leg is so badly fractured that it has to be amputated. So you can ask in other hospital, but it cannot be saved. But still they will ask. I don't know whether it's true or not. I heard the other day one girl died on a scooty, was hit by an ambulance near. And she died on the spot. See, someone's daughter, someone's sister, someone's friend. It's the price of, ultimately, what is the value of human life in a society? That we have to ask. Every society has to ask this question. It's so risky. And many people have to ride bikes out of compulsion. Believe me, in developed countries, more people ride bikes due to fun, for pleasure. But in developing countries, people ride bikes out of compulsion because they have to travel to work. They cannot afford a car. That is why. Bike safety is very important.
59.
All right.
We have not received the case diary.
Wait, please, Your Lordship. My lord may recall on the last occasion, my lord. The last
Yes.
order, my lord.
Mhm.
Here, the petitioner before Lordship is a bank employee, my lord. Chief manager, my lord. On
Okay.
verbal instruction, he released certain money, my lord.
Remember.
Yes, my lord. Later on, my lord, the bank indemnified, my lord.
almost the entire money has been returned back,
No
And the-
interim, right?
my lord.
There was no interim.
No interim. So my lord, 29 days, almost 1 month, my lord. Can the interim be considered, my lord?
No, diary has come.
That is not received. Out of 60 lakh 14,000, my lord, 57 lakh 81,000 returned by the bank, my lord. Because my lord, that criminality part whether my lord can't. Yes,
Otherwise, bank matters, we have to be little careful, right?
yes, my lord.
Would agree.
I admit, my lord, gross negligence.
We all agree.
I should not have done that, my lord, because they were regular customer, my lord. On good faith, we have done that. I have annexed all those documents, my lord, where they have admitted the receipt of money, my lord.
It will show like what is it on 1, 2, 3, 4. 4 will show, huh? The case diary is called for has not been received. Issue for its reminder for the same. Which Thana? Silchar.
Yes, still please.
We can get it within a week. Also. The learned council at this stage makes a prayer for interim bill considering the detention till now since
My lord, 7/1/2026.
month, about a month. Good stuff. It is contended that the petitioner might have done some irregularities on good faith on the instruction of the client, made some transaction. Okay, I'll not say that. Harms you. Had made some transactions in good faith upon instruction of the client, instruction of the customers, instruction of the petitioner. But the petitioner subsequently reneged, reneged from it and filed a criminal case against him. He submitted that he had no criminal intention and a significant component of the money in question has already been returned by the bank.
By the bank.
In the given facts and circumstances, perhaps the under trial detention of the accused can be put on hold for the moment. Accordingly, 30,000 with 1/0 interim bill. Subject, his statement must have been recorded. Must have been recorded. He was arrested.
He is arrested, my lord.
Cooperate with remaining investigation. Shall make himself available for examination again if necessary.
Yes, my lord.
Shall not hamper or temper our duties. Issue reminder for the case diary.
So should I fix a long date or short date?
Medium date.
Then 18/2.
Okay.
Yes, my lord.
Or you want it later, a little later from them? Investigation can progress a little bit. We can give a little later also. Week thereafter. Thereafter,
25 or 26.
something like that. 25?
25.
Okay.
Yes, my
You have some difficulty?
No, I'm happy with it. Deeply obliged, my lord.
Landing item 10,011.
As per our instruction, lordship, we have in our office, we have the case diary, lordship. So lordship, I pray for fix another date that we have go to the case diary and it is in office for in this case. So
Okay.
day or day after tomorrow,
CD is not available.
it is here, but I have to control it, lordship, against this petition of lordship. Day after tomorrow.
10 and 11. Is it okay?
Okay, lordship, if possible tomorrow, lordship.
Tomorrow after, if
Day
you
after
can,
tomorrow, lordship, it will be better fast, lordship.
it's coming up for a
Anticipatory
bail hearing, right?
bail hearing.
Why it's no.
It's a motion matter, lordship. They have prayed, yes, CDs, another case CD is here, lordship. That's why we have taken instructions that whether CD is here or not, lordship.
Just a minute, I'm just had a mix up. Which one? Oh, so this matter, no? Acha, okay. Right. Okay, yes.
Some earlier cases are there, Lordship. That's why we have taken instructions regarding the case diary.
It is there in the office.
Yes, Lordship. So we have to go through it. So day after tomorrow, Lordship.
Okay. Just hold on. The case diary is stated to be available in the office of the learned public prosecutor. And as it was requisition in connection with some other bail applications. And the learned additional PP prays for posting the matter day after tomorrow. The prayer is allowed. List the matter on
6 to 26.
6. In the meantime, you can get hold of one of those orders in regular bail where bail was granted. Okay.
God bless you.
Bail hearing 21.
21 Lordship scan copy was there, but we have to go through it.
Lordship, what happened in this case, next date is fixed on 25 to 26, Lordship.
Yes, sir.
I'm on interim, Lordship, I'll appear, Lordship, there. Because the co-accused are appearing already, Lordship, before they.
He's already on interim. No?
I'm already on interim, Lordship. I'll go and apply for the regular bail, dear Lordship. Till then, some protection may be given till 25/6.
That can be one option. Yes. Otherwise,
Otherwise, scan copy was there. We have to go through it. We have
Go
not gone
through
through it.
what is the case otherwise?
Regarding basically against my husband, Lordship, they're taking money, Lordship, and some establish himself as a fake officer, Lordship, in the missing autonomous council, Lordship, and giving fake order of supply regarding bracket and all, Lordship. They use racket, Lordship, that mainly basically against my husband. And
Anyway,
I'm
when
his
is the
wife.
date? Yes, sir, I get it. When is the date? Next week?
Date is 25/2, Lordship.
25. It's a bit long way. Otherwise, you could have extended in taking that up. Then you go through, fix another date. Okay, interim will be extended. The case there, the scan record has been received, and scan record has been received by the learned additional PP. Seek some time to go through it. Seek another date to go through it. It is submitted by Mr. Munir, learned counsel, for the petitioner that next date for appearance.
Appearance, Lordship, because other accused person are already appearing, Lordship.
Next date for appearance is fixed on 25/2.
25/2/2026.
26. Okay, dispose it off. Maybe.
I had a matter, Lordship, item 56, Lordship, that.
56.
Connected.
No, Lordship.
No.
Notice is served or not, that notice is served.
Huh? No, the earlier matter date, we have not fixed the date.
Oh, no, more festival.
19 before 25.
Can it be on 18, Lordship, then?
Not
It can be
18.
18.
56.
56 is connected.
Not earlier, but that was. Wait, is taken no, notice is served or not, notice served.
Notice this, doing vision, no?
Also time being. Notice was soft.
Served. Sixty days in custody, primary facie materials are against the petitioner, Lord.
Heard. Invoking 483, the petitioner is seeking regular bail in connection with Patharkandi PS 253 of 24. He was arrested on 13/12/2025.
Yes.
On What was the date of the FIR? On 1/12/2025, one FIR was lodged with the allegation that on 25/11/2025 in the evening, on Iqbal Hussain, the petitioner, came to the house of the informant and took his son Sadiqul Haq on a motorcycle. Later, he was found in an injured condition and taken to the hospital, but he was found to be dead. Stop. Subsequently, a video recorded by one passerby was stated to be sent to them. Which showed 6 persons assaulting the petitioner, the deceased, including the present petitioner Iqbal Hussain. Case diary has been received. The petitioner counsel submits that the petitioner and the deceased were friends, and that the deceased unfortunately was also into drugs. Nevertheless, the prosecution submits that the petitioner is implicated sufficiently by the materials. Investigation is not yet over. In view of the said situation, perhaps it may be prudent not to grant bail at this stage. Accordingly, the bail petition stands rejected at this stage. Return back the case.
Much obliged, Your
After
Lordship.
some time.
22.
May please, Your Lordship. Create as bail application, my lord. Petitioner is on injury, my lord, and statement of the petitioner has been recorded and cooperating with the investigation, my lord.
Okay.
FIR lordship will find case 15. Is that under section 105, my lord?
Yeah, Lordship, earlier only up to the case they was called for, but the CD is updated on 17/11/25,
Quite long,
quite long.
quite outdated.
It is not up to date. It's only interim, Lordship. We have sent back the case there.
Yes,
For
I think-
update, Lordship.
You wanted to say something, please?
My lord, allegations is, my lord, an accident took place, my lord, involving, my lord, one JCP, my lord, in the brick field of the, my lord, petitioner, my lord. Though the petitioner is the owner of the, my lord, brick field, my lord, but he is not the driver of the, my lord, brick field. And unfortunately, my lord, one minor child died in that accident, my lord. But I am not the driver of that, my lord, JCP, my lord.
Anyway. So interim is there. The case diary is received, but it is submitted that last endorsement is only of November 2025. The case diary may be returned back and procured again for the next date with the updated investigation. The interim bail stands extended till the next date of listing. What is the IA?
IA, my lord, there is a, my lord, it has been recorded in the order dated 4/4/25, my lord, that I am not the owner of the JCB, my lord. That corrections, my lord. But in fact, I am the owner of the JCB, my lord.
Oh, so that one. We'll dispose it.
My lord.
Huh. You submitted that this IA.
Page 8, my lord.
I 342.
Page 8, last line, my lord. He is not, the word not has been, my lord. Page 8, my lord, last line.
Is it? Oh, so can I correct it? It's by another judge. I can correct it.
Just one
Count by.
Nothing else. It was actually.
Hmm?
That lordship can say correct it, lordship. Yes.
Appropriate means.
Yes, like what it means.
Let it remain, my lord, after sitting, my lord.
Because the order was passed by the learned. That
Let it remain, my lord.
Not now, wait.
Lordship fixed it, my lord.
Interim extended.
Maintain.
This stone,
23/2.
23/2.
We have to send it,
Okay.
send it back. Lordship.
Yes. 23-2 or even later if you want.
Yes, 26, Lordship, 26.
26-2.
26 too much.
All right.
33.
22 of in this case, charge sheet submitted.
One of the earlier occasion, one of the I prayed for one of the call for the scan copy of the charge sheet in this matter.
It is he's on interim bail.
Interim bail.
The petitioner was granted interim bail on 3/9/2025. Mr. Borbuya and DP Goswami, para 2 and 2, 3 and FIR. The prosecution submits that in the meantime, upon completion of investigation, charge sheet has been submitted in the case. In view of the completion of investigation, the interim bail granted by so and so is hereby made absolute subject to the condition of available for trial if one commences, not hamper or temper. Number 3, he shall not commit any illegal activities or offences. Violation will entail cancellation of the bail, disposed of.
Deep level.
24.
24 of the petitioner in interim, we have not received the case there.
Received?
Not received.
Not received.
No, I'm on interim, my lord. That may be continued.
Case diary is not received. Issue reminder. Interim bail 19/12/25 extends extended till the next date of honesty. You can choose the date.
22, 202.
25.
May I please, your Lordship? Lordship, petitioner on interim bail, Lordship kindly have a look at the Ezahar at page Lordship 10.
Lordship 25, I have some submission Lordship. Interim bail Lordship, his statement not in the case diary Lordship. The case diary updation in 6/12/25.
Fairly, not very.
It is not
old
in
document.
time on 19/12/25. That's why his.
He has appeared perhaps.
Lordship.
That's why his statement is.
And Lordship, his shop owner purchased a mobile handset that was handed over to him. He returned it to the IO on after Lordship enlarging him on interim bail, Lordship. That he has returned, his statement was recorded.
So yeah, we have sent it for updation Lordship along with his statement Lordship because he is in any time. We have sent it back for updation Lordship.
For updation.
With his statement Lordship.
The petitioner was granted interim bail on 19/12/2025, pursuant to which he is submitted to have appeared before the IO and his statement recorded full stop. However, the case diary though received is not is having the last endorsement prior to the grant of interim, and the statement is not reflected then thereunder. Therein, but the case diary may be returned back and procured again with updation. The interim stands extended.
26/2.
26/2.
All right.
26/2.
26.
Please, your Lordship.
Yes.
Lordship, actually on the last occasion,
Yes, yes.
stated before this honorable court that on 11/12/2025, the co-accused, that is the wife of the present petitioner, went on bail and on that particular order, it was submitted that charge sheet has been submitted by charge CS number 6225. So today it was fixed for whether the charge sheet has been submitted.
Okay, no problem.
As per the report of the charge sheet has been submitted, I have it 11% of the report Lordship. Under the above facts and circumstances, prima facie case is well established against the arrested accused person Noor Jahan Begum. So I have submitted charge sheet via Haflong PS charge sheet number 62/25 dated 30/11/25 under section 313, 336, 338 against the arrested accused person Noor Jahan Begum Lordship, before the honorable court for fair trial. On the other hand, the case is kept open as the accused Atabur Rahman was hiding himself from police arrest. However, he got interim bail at your honorable court by the order at 7/1/25, but till date He has not appeared before the IO for recording his statement and is not cooperating with the investigation in this case.
This bail is for what is for whom?
It is for Atabur Rahman.
Acha, Atabur Rahman.
Atabur.
Okay, he should appear then.
Actually, the thing is that when
That,
he went to Haflong, it was not a suitable position there. He found it not in a
Oh.
suitable position. So he sent his statement through postal and we have the postal receipt. and
That is not,
everything.
there was it acknowledged. CD is there.
CD is here, Lordship, but see, in the CD, his statement is not in here. From FSC materials against the petitioner is there, and that's why bail objection is here.
Hmm.
And he is not cooperating with the investigation after getting his protection. Lordship.
It was also received by the police on 28/1/2026.
Mhm. We can, there are some materials he says, prosecution says. So we can say, give an opportunity to him to contact the IO again and send him, contact if there's any danger to one's life, that can, that is understandable. Whoever he is, but thing is, he can try again. And then
He will try.
electronically record this, now it is possible, no? WhatsApp,
Through WhatsApp. Yes, it can be done. through
WhatsApp video or WhatsApp
but
audio, WhatsApp
physically-
video is better.
It is possible, your lordship, but the thing is that if he again goes there and something happens.
No,
to that particular
he
person-
cannot, without going there, I'm saying,
Yes, yes, definitely. He can, do it.
without going there.
For the
Yeah,
record,
it's what is the allegation? He's taken money from
He is,
people.
he is demanding money and taking money from various persons
Hmm.
for installation of BSNL tower.
Oh, they must be after him then. All
Yeah,
of them.
along with his wife also.
Hmm.
So someone's for 50,000, someone's for 60,000, lots of money he has collected from the various persons.
but with whom the agreement is,
Yeah.
he has entered into agreement, the informant, his name is not reflected in the FIR.
Heard, he does. Council, ভুল হয়েছে J Das, right?
Vedas,
Yeah.
lordship.
J Das, learned counsel for the petitioner. Wait, P Deka was there. P Deka is also there in the case?
P Deka is
Oh,
also there.
then it's okay. J Das, you're J Das, I know. And counsel and DP Gosam. The case diary has been received and charge sheet has been submitted so far against the wife of the present petitioner, namely Noorjahan Begum. But the investigation has remained pending with regard to the to the present petitioner. And it is stated that he has not appeared before the IO pursuant to grant of interim. Learned counsel submits that as reiterates that due to some concerns regarding his safety and threat to life, life and limb, he could not go to Haflong physically and sent his statement through post. However, actually, this is a examination. Telephonic will be better because examination is it's a question answer, right?
Video
Question
conference.
answer, like an interview.
Yes.
Right. So rather than my, like a pleading, so it will be better. And no, if he sent it, it's okay. The
Lordship, for the record, I may submit the statement with the postal track.
Yes, yes. The land council furnishes a copy of the postal receipt along with the statement. Full stop. The investigating officer shall look into the aspect of receipt of the said statement. Full stop. Further, effort may be also made at this stage to record the statement of the petitioner electronically. Electronically through audio/video means. This you need, you can return. You are submitting something,
Yes, I'll submit.
it will be kept in the record, okay? So case diary will be returned back. Case diary will be returned back and procured again,
Yes.
but it will be submitted to the court after charge sheet.
Against one charge sheet is
Another
submitted.
part will be there. And the return back, the relevant part of the and how should we say it? And maybe procured back for the next date. We'll say like that. Actually, it should be scanned of this and the original of the supply.
We have another copy as their lordship, and
Yes, sir.
that can be sent back.
Yes, I'll remain like this one. Procure for the next date. Date
26 to lordship.
26/2, okay,
Lordship.
26/2.
Can it be 20?
Informant, right?
Informant,
Mohan Kolita.
Mohan Kolita.
You let him take the instructions. Today is 4, no?
Yes.
Yeah, we can fix it on 6.
Yes.
6 or 7. Too many matters not fixed on 7.
Lordship.
6, okay,
Lordship.
list on 6.
Would like.
Unlisted item 1 along with 57.
That is your lordship.
Yes.
Your lordship, earlier, your lordship, before filing the charge sheet, your lordship had rejected twice this case, your lordship. Your
Okay,
lordship,
that's-
after
that's
filing of the
okay.
charge sheet, your lordship,
Mm.
actually, since I was pursuing a BTech degree, your lordship,
Mhm.
my exam schedule was there, your lordship. Accordingly, I filed a bail petition in the trial court, your lordship. I was granted interim bail, your lordship. Your lordship will find this bail order at page 77, your lordship.
Yeah,
And Annexure 4, your lordship.
I have noticed that. Okay.
Petition so and so, your lordship, might be. Page 77, your lordship.
77.
Your lordship. Petition number 2117/25, filed on behalf of the accused Oyon Chaudhary.
Mm.
Your lordship, this petition and the relevant portion, other accused were also filed their bail petition respective. However, those were rejected, your lordship. I was allowed bail, your lordship, will the relevant portion, your lordship will find at page 80.
He was
The
given
third
interim.
paragraph, considering the fact the accused Oyon
Yes, sir.
Chaudhary
For
had
example.
to appear so and so for 20,000 your rupees,
Mhm.
and the bail was allowed till 19/1/2026, your lordship. My examination got over, your lordship, on 18th, your lordship. I boarded train on 19th, so further extension was given. In the meantime, your lordship, a date for framing of charge was there, your lordship. There on that date also, your lordship, before that 19, your lordship, on 3/1/2026, page 82, that may be seen, your lordship. Accused Oyon Chaudhary is present, your lordship.
Mm.
Your lordship. After that, your lordship, finally, my bail was extended till 28, your lordship. I again appeared on that day to surrender, your lordship, at page 84, your lordship. 28. The accused Oyon Chaudhary has surrendered before, your lordship.
Mhm.
I was granted bail, your lordship, all along, your lordship. 3 dates were there, your lordship. On all the dates, I appeared, your lordship. Now the charge sheet has been filed, your lordship. There is nothing to investigate, your lordship. So my conduct there in the I participated in the trial, your lordship. I had been regularly attending, your lordship. And now I have been, your lordship, remanded to custody, your lordship.
Mhm.
I did not avoid the trial, your lordship. Moreover, your lordship, if your lordship goes to the charge sheet, your lordship,
Mhm.
your lordship will find at page 43, relevant portion, your lordship. The CDR analysis, your lordship, our mobile phone, everything was seized,
Right.
your lordship. The CDR analysis only was done in case, in respect of that, the prime accused, that the
Stephen
main
Hansen.
accused, Stephen Hansen, your lordship. Why it has not been done against us, your lordship? Had I been even remotely, your lordship, involved, your lordship, I would not have pressed, your lordship. I am not even remotely, your lordship, involved in this case, your lordship. There was no money transaction from my mobile, my account, your lordship. Only because that the accused, the prime accused, under mob compulsion, your lordship, mob force, he took my name, your lordship. Even in the court, before the magistrate, he did not utter my name, your lordship. Moreover, your lordship, the 180 BNSS, your lordship, the statements, your lordship, that has been taken from the witnesses, your lordship, all are almost similar, your lord, copy paste mechanically done, your lordship. Just to frame me, your lordship. Here it is a clear case of, your lordship, tainted investigation. And the basis of this tainted investigation, the charge had been filed, your lordship, and the court below mechanically has framed charge against me, your lordship. So here, your lordship, I want to submit that, your lordship, I am appearing in the court below, your lordship. I was granted the bail. I never misused that, your lordship. The investigation part is over, your lordship. I have no scope to, your lordship, to alter or influence any evidence, your lordship. That part is there. I am from the Madhya Pradesh, your lordship, not I'm even local, your lordship. I cannot influence anything, your lordship. That place is not, your lordship, known to me, your lordship, properly, your lordship. How can I influence your lordship? Moreover, I'm newly married person, your lordship. My wife is still there, and only she is there, your lordship. My father is an cardiac patient, your lordship.
When
He
did
had
you marry?
undergone, your lordship.
When did you marry?
Your lordship, the same year, your lordship, last year, your lordship. Moreover, at that particular time
This
when
aspect,
he
I think I have
went
not
missing,
heard.
your lordship.
No, I think I don't remember
Yes,
hearing this aspect that he was married last year. only.
your lordship. She is alone there.
Anyways, no. But I mean, the prosecution is otherwise, their contention is that
Some
uh,
witnesses may be
some
examined,
witnesses may be
your
examined.
lordship.
Otherwise, stage is at the stage of trial. No doubt.
Like, that party is there, your lordship.
Yes, yes.
That has to be looked into.
No, no,
whether
I'm not expressing
independent
any
court,
mind. I'm just,
your lordship.
yes,
Then none of the witnesses directly implicates me, your lordship. Only hearsay, your lordship, we have heard something like that, your lordship. Is there any chance, your lordship, there are very remote chance that I will be, your lordship, convicted, your lordship.
anyway.
Moreover, at that particular time, when at the time of the commission of the crime, your lordship, I was there in the office. It was under CCTV surveillance, your lordship. Everything was recorded in CCTV. Why they have not seized the CCTV, your lordship? My wife had been repeatedly requesting them to seize everything. I boarded brass, and I even attended a birthday party at the office. That a photograph I have annexed, your lordship. Your lordship will find at page 93, your lordship. The time is also there in the mobile that was recorded, your lordship. After that, your lordship, I gave message to the bus driver that our residential place is accommodation is at Lanka. That is around 2 hours journey from there, your lordship. I boarded brass, messages are there. I visited the wine shop there, your lordship. That photograph I have also annexed, your lordship. That wine shop has also CCTV camera there, your lordship. That I even requested them to seize the CCTV recording and everything, your lordship. Why my CDR analysis has not been done, your lordship? My question.
That factually helpful trial.
The trial, your lordship.
That factually helpful.
Your
helpful
lordship,
the trial,
my
lordship.
wife, she is
The question
very
of
young,
trial.
your lordship. She is alone there. Can she take proper defense for me, your lordship? Unless I come out, your lordship, I'll be unable to take proper defense for me, your lordship. And my father is an ailing person, your lordship. He cannot even move. He has very recently, your lordship, he has suffered another stroke. Will it be possible for me, your lordship? Even I had been remotely involved, your lordship, I would not have insisted, your lordship.
No, I mean, everybody have
Yes, your lordship.
a right to defend yourself.
Yes, your lordship.
Anyway, so unless somebody confesses or something, anyway. So
That under compulsion, your
I'll
lordship.
consider it
Yes,
properly.
your lordship. Go through it, lordship.
I'll write it inside, but submissions to him.
Related investigation.
You're Mr. Iam.
Ahmed, your lordship.
Iam, Learned Counsel for the petition, assisted by.
No, he is for item.
Oh, you've, sorry, yeah. I've submitted, recorded your submissions, I think.
Similarly also, my lord, my senior also, my lord, not.
They submitted that petitioner was granted interim bail by the learned court below for his examination. And thereafter, he voluntarily surrendered before the court and never misused the bail conditions. Semicolon, that comma. The police did not do CDR analysis with regard to the petitioner, like it has been done in case of the main accused, Hanse, full stop. Semicolon, that the petitioner is not at all involved in the alleged offenses. Semicolon, that the investigation has falsely implicated him. And charges have been framed mechanically. Full stop. It is also submitted that the petitioner has been married only 1 year back and his wife lives alone, and that he will be hampered in his defense if he remains in detention during trial. Full stop. It is also submitted that the most of the witnesses are with regard to him are hearsay. That's not
Or copy paste, your lordship, all similar, your lordship. Let me. You told, your lordship.
That's all.
Your lordship.
I'm not reserving, I'll dispose it.
In my case also, my CDR analysis was not conducted.
No, no.
And the next date perhaps has been fixed on 16th.
15, yes, that I have to record. I've given
For
part of
the
the
evidence
petition.
of-
Yes.
Oblige your
Today only hopefully. We'll have Any other thing? No. No, that's- Just leave.